Another issue that might come up in dealing with an employment contract is whether there's been certain representations made to the employee that has led to the establishment of the contract, and those representations were either false or made negligently. The famous case involves a person living in Winnipeg who was invited to work with a company in Ottawa and was promised that the company had devoted its resources to establishing a new program, a new computer process program that that person was being hired for. And so the employee resigned his employment in Winnipeg, went to Ottawa to take the job, and when he got there, he found out the company had not made such a dedicated mission to pursue this objective, and soon after arriving there, the employee was assigned to another position. The agreement that he signed also had a termination clause in it. So the employee sued, arguing that there was a negligent misrepresentation made that caused him to enter into this relationship, that he had moved himself from Winnipeg to Ottawa, gave up obviously his previous job, and now had to move back and incurred all these damages and costs. So the court, in first instance at trial, agreed with his submission. The Ontario Court of Appeal reversed, and the Supreme Court of Canada upheld the trial judge decision. That was a big case, and it's called Queen versus Cognos, C-O-G-N-O-S. But the important thing about this case is not only that it was actionable based on negligent misrepresentation, but also the court looked at the foundation of the claim, and in this case, the employment agreement did not specifically deal with the alleged misrepresentation, which was an important issue allowing the plaintiff success in the claim. If the contract, for example, had actually dealt with this issue, and it said, we are not committing ourselves to funding this project, it's hypothetical, we're not sure about it, whatever, then there would have been no claim. So and it's not necessary that there's a physical relocation to establish the claim. A lot of the cases do involve it, but it's not necessary. But what is important, if the employee asserts, I was told something that I relied upon to my detriment, and therefore I enter into this relationship, when those are the facts, the agreement, if there is one in writing, if it actually deals with that alleged misrepresentation and contradicts it, then there's no claim. So you have to be very careful about examining the employment contract and the misrepresentation that's alleged to make a claim. Where there is a claim, it can be substantial, and because it's a claim of what is called tort, the damage claim is not taxable. I'll deal again with various tax issues on termination relationships later, but that's a big issue that often arises. Thank you.